Today we are going to do an extraordinarily deep dive into the Sham Trust concept, and I'm hoping this really is one of the deepest dives you'll see. And I've got very extensive slides, so what I would say to you is you can kind of let this wash over you. The slides will be shared afterwards, or certainly you can contact me and I'll share them with you. So I packed a lot of information, recommended reading cases, so you can just sort of sit back and listen, and no need to sort of take too many notes. So let's dive into it. I'll just say a few words about myself, and then I'll show the agenda. So the first thing I wanted to say was I really have skin in the game on this. I've done every single role in a trust company, from the T-boy from the junior trust administrator all the way up to MD in multiple countries. So I know trust administration in the offshore world inside out. It's really what I've always done. And more recently, I actually ended up setting my own legal consultancy, so Ballum Law, and we look after ultra high net worths and their companies that have lots of cross-border problems. So if you've got a client who's got sort of outgrown their local advisor maybe, and they've got global tax, legal, regulatory and governance issues, where we absolutely excel in talking to people about that and helping solve them, and what I call future-proofing their wealth is really what we do. So, and I'm very involved in STEP. I've got quite a background in crypto as well. So I chaired the crypto committee for STEP for a few years, and I've co-founded a project. And Ballum Law has a whole crypto business line to it as well. We help a lot of crypto founders out with their businesses, and it's all to do with structuring trust companies, but to a whole new world. So let's talk about why I wanted to do this topic. I have real beef with the whole Sham Trust concept, and the reason is because when I was a young administrator, it is all I ever heard was, "Oh, it's a sham. That could be a sham. That could be a sham," and it really, really annoyed me. And I was pretty certain that people were saying it out of fear, out of intellectual laziness, out of cowardice, that they didn't want to sort of tackle something. And so I really set out to actually understand it, because I was pretty sure that they were wrong, and I wanted to understand it so that I could say to people, no, it's not a sham actually, or this isn't a sham. And a lot of the time I thought they were just trying to avoid my signing. And so I did a huge deep dive on this topic. So I've broken it down into a number of parts. So this is how we're going to go through it. We're going to look at where it kind of emerged from, and then the presentation is not just about shams. I'm also going to go into kind of how the whole offshore world developed and the timeline there. And then I've got a really exciting epilogue at the end. So my original thesis on this was written up to about 2016. So it didn't include this key case, Pugachev case in 2017. And everybody used to say to me, "Oh yeah, your paper's rubbish now because Pugachev's overwritten that." For this presentation today, I finally sat down and reviewed Pugachev, and it's extraordinary, to the point that it just completely backs up my point. So we'll come to that at the end. And I think Pugachev is really the latest Sham Trust case that there is. Okay, so let's move on to the where it all kind of came from. So in the mid-19th century, the world was rapidly changing thanks to the Industrial Revolution that was underway in Great Britain. The first railway connecting Stockton and Darlington was unveiled in 1825, revolutionizing travel and commerce. So with this surge in industrial growth came lots of innovative new financial instruments and legal arrangements that facilitated the increasingly complex commercial agreements. And so it was that during this period, the courts had to face the inevitable abuse that these clever devices were sometimes being used for. So historical English courts had always, and still do, uphold the doctrine of freedom of contract, and only very rarely would they depart from the observed, or rather the documented intentions of the parties. But in the industrial days, the Industrial Revolution times, the courts were increasingly being faced with the challenge of discerning whether certain legal documents and agreements were genuine, or were they merely a facade designed to mislead others. And so you can imagine in these times, there's lots of as things got more complex, there's a lot more sort of nefarious people coming out and doing things, a bit like as we see with crypto these days. So two significant railway cases from this era illustrate the court's struggle with what was not at the time solidified as, but what might be loosely or carelessly called sham arrangements. So we had the Yorkshire Railway case and the North Central Wagon case, where the courts had to determine the real nature of the lease agreements, which involve railway rolling stock. So the judges in these cases began to establish a precedent that the courts must look at the real transaction, not just what the documents in front of them claimed. So this shift in judicial approach signaled the beginning of a doctrine that would later evolve into a potential concept of the Sham Trust. Now, these cases all involved like hire and purchase agreements or sale and leaseback agreements. So you can imagine these were very clever financing arrangements back in the day. You know, a railway company struggling to raise finances could sell its stock and then lease it back and carry on business. But as we've seen, this was being abused, and there were often arguments. People say, well, no, actually, I still own it, or no, I don't own it, depending on what suited them. So this actually came up to Parliament, and Parliament passed two important acts known as the Bill of Sales Acts in 1878 and 1882 to regulate these devices. And this brought us to our first Sham Trust case. So we have Re Watson. So this is a case from 1890. So in 1890, in Re Watson, it brought the issue really into sharp focus. So here we have the bankrupt Mrs. Watson attempting to borrow from a Mr. Love money against her household furniture. And she then claimed that the arrangement was a hire and purchase agreement and not an unregistered bill of sale, which would have meant that the transaction was void because she should have registered it under the Bill of Sales Acts. So the courts had to decide if this arrangement, which was presented as a legitimate transaction, was actually a sham. The judgment hinged on whether the agreement was a true loan or simply as a disguise to evade legal requirements. So Lord Esher, in his judgment, questioned whether the court was bound to accept the form of the agreement presented to them, or whether they could look beyond it to uncover the true intent. This notion of looking beyond the form and seeking the substance became a cornerstone in identifying potential sham transactions. So we have this maxim in equity and law of form over substance, don't we? So the court did not feel they were bound by previous decisions, preventing them from looking more roundly at the contract. So this is a really key case. You could say this is the authority for not just reading the plain wording of what an agreement says in front of you, that actually the courts are now going to actually sort of step outside the four walls of an agreement. So that's really the key case from that. But not necessarily a sham case, but you know, we're starting to see the judiciary now looking at things more than the agreements. Then we have our dear Lord Denning. So Lord Denning's a really very famous judge, very creative judge, controversial a little bit as well. But he's put his sort of his oar into the Sham Trust concept a little bit here. So the final point I wanted to make here was about something called the true construction of the contract. So you've probably heard of that. What is the true construction of the contract? And here, what Lord Denning was focusing on was what were the intentions of the parties, and examining all the evidence of their intention. So in the previous century, the courts had, just as Lord Denning put it, obsessed with their idol. And what he meant by that was, their idol was freedom of contract. So Lord Denning here really kind of, started to roll back freedom of contract a little bit, saying, well, actually, no, we're going to look at what the people really intended. And so there is likely here an emergence of some sort of doctrine whereby the courts were no longer just looking at the document themselves, but it could just as easily be found to be a mistake, an intent, or a public policy decision. There does not still appear here a clear concept of a sham at this point, albeit if there is, it relates to some sort of devious intention to conceal. And I think that's one thing Denning made clear, this kind of requirement for mischief, which we'll talk more about. So please do jump any Q&As in the chat group, and we'll pick them up at the end. But feel free to dump your questions in as we go along, and we'll pick them up at the end. Now, before we move on to our next timeline, around the same time we had two key trust cases. If you're a trust administrator and you don't know night and night, you need to redo your STEP diploma. The classic case on the three certainties of a trust, and as you know, one of the certainties was the settlers' intention to create a trust. And then we also had Jones versus Locke. This is the famous case where a father put a check for £900, and bear in mind this is in 1865, so that was a lot of money, in his baby son's hand, and said it's his, he can do with it what he likes. And then he died 6 days later. And the court had to decide, well, did he really mean it or not? And this, of course, is in relation to trusts. So a lot of the time, intention was already kind of looked at under contract law, but this is getting applied into trust law. So around this time, again, the concept has been introduced that the intention is important, not just what the agreement says. But it's still hard to see a sham doctrine has evolved, hasn't it? So we can see something, but I don't think we see a sham doctrine yet. But things get rather now a lot more interesting as we get into the 1960s and into the 1990s. So we're going to have our first really key sham decision now, which is Snook. Now, your advocates, my enemies, advocates of the sham argument, consider this a sort of canonical decision in Sham Trust theory. And again, in this case, we meet up with our old friend, the hire purchase agreement. So this time it was all about a motor car and not furniture. Now, you had Lord Diplock here. This is sort of Lord Denning's enemy, another famous 20th century judge who really crashed up against Denning was involved. So you've got some of the finest legal minds of the century looking at this concept, along with my mind. But Lord Diplock sort of found himself compelled in this case to articulate an apparent sham concept. And he sort of bumbled through it somewhat. His speech was mixed with a lot of wording showing his reluctance and doubt around it. You know, he says here, it is, I think, necessary to consider what, if any, legal concept is involved and if it has any meaning in law. I mean, very, very, very wishy-washy language there, but there was a very important thing that came out of this case. So here we note that the elements of deceit were mentioned, but further, Lord Diplock introduced this concept that there had to be a common intention. Now, this is very important because, as you will recognise, this becomes important later on because, as you can foresee, there are plenty of cases where perhaps it is true to say that the settlor may well have been acting deviously, but the trustee wasn't. And we'll look at that at the very end. And actually, Pugachev is an extraordinary case in this regard. And I think that was kind of one of the sort of the ways of looking at this at the time. If the trustee wasn't involved, then it wasn't a sham, and that's the end of it. But look, Lord Diplock's analysis here does seem incomplete. And in this case, his decision was obiter dicta and not ratio decidendi. Now, what that means is that it means that this case did not turn or was decided on the sham point. And so the sham point and any other points that were raised that were not considered as that part of the decision are not binding on future case law. So as you know, under the common law, you're bound by previous cases, but you're only bound by what's called the ratio decidendi, the key point that actually decided the case, and you're not bound by the other comments by the judge, although they might be seen as persuasive, particularly if they're like someone like Lord Diplock. So nevertheless, proponents of the Sham Trust theory sort of clung on to this case, but it really was, okay, a senior judge, but still obiter dicta. But let's perhaps put all of this in its context now. We need to put this in a certain context as the backdrop to the sham argument really evolved in line with a much changing world after World War II. And you know, we're all familiar with the fact that trusts started back in the Crusade days with knights putting their property on trust or on the medieval fiofe, and that being held for them. And of course, that was only land in those days. And then in Victorian times, you had this sort of more concept of the gentleman trustee, you know, the sort of wise grandfatherly, fatherly figure that would act as trustee, probably not being paid, and would look after the unwieldy settlor or the family that didn't understand complex matters. And you know, he was there. He was undoubtedly a model fiduciary, only acting in the best interests of the beneficiaries. But what we, of course, now sort of surged into the 60s and 70s was solicitors and accountants that specialized in trusts, and even people called tax advisors who advised on how to lower your tax and things like that. Insane. And another change was that as land was no longer the sole asset that people had or were put into trusts, really the trust transferred from a conveyance device to a management device. And I actually think that's a way better way of thinking of a trust today. A lot of clients, I think, underestimate that really the main benefit of having a trust is that you've got a team of really great administrators with that know how to administer all sorts of assets and have contacts all over the world to help you do it. They're management devices for wealthy people in many ways. And these professional trustees and wealth advisors were developed. And all of this was really tacitly approved by the judiciary. You know, there was a case, this case is still quoted today by tax advisors, the Duke of Westminster case, which basically said that a man is free to organise his affairs as he chooses. So you'll still hear tax people claiming that. And so things had changed a lot. And this is really where the Sham Trust argument really then started to be brought in. Now, if you want to read the best paper I think you will find on how the offshore industry actually started, it's Donovan Waters' paper, The Trust, Continued Evolution of a Centuries-Old Idea. And what he shows in this is that in the 1960s, you had very high levels of taxation, especially estate tax in the UK and the US. People were getting richer, so there was a middle class emerging and they were falling into taxes. The state was starting to take much more interest in people's affairs, and clever tax advisors and such were finding very clever ways to reduce tax. Further, the offshore world was created. So the reason the offshore world was created was because in 1957, the Bank of England had to impose actual capital control restrictions on the pound by non-UK residents following the Suez Canal crisis. So British banks were forced to finance trade in US dollars instead. And basically the Bank of England sort of said, well, as long as this is done outside the UK, we'll turn a blind eye to it. So you had all the British and American banks setting up in Jersey, Guernsey, Bahamas, and these places in this unregulated zone to basically get around this issue. The Foreign Office in England also saw this as an opportunity to kill two birds with one stone, because they thought, right, we can get all of these former Crown possessions, colonies off the payroll now, turn them into specialist Euro market booking centres, and people from London were seconded to train locals in how to be bankers and trustees and that sort of thing. Donovan Waters, he does actually comment about the Sham Trust. It's a really outstanding history of the trust, but he talks about that, in his opinion, shams are in fact a loose way of talking about the apprehension that trustees have, and that they have, that they could be accused that they are, when they are subject to consent or direction requirements from a settlor, merely agents for those individuals. How true is that? I mean, that really hits the nail on the head, doesn't it? That is exactly what trustees are worried about. And so there we have it. So, and he mentions this also here in his paper about offshore jurisdictions have not tackled the sham issue, but mainland lawyers have often too much, and they've muddied the waters by speaking vaguely of sham trusts. And that's very true. Not until later did the offshore jurisdictions really get involved, and the English lawyers were throwing it in everywhere, which we'll see. So anyway, let's jump back into a next case. So we now get to around the 2000s. We're going to flick back in a minute to a key offshore case, but I thought we'd have a quick look at this case involving this Welsh farm, because it shows you what people were doing. This was a desperate family trying not to lose their farm, and they were advised by an expert to create a trust and that sort of thing to try and protect it. So a bit of a sad case. But again, this is lauded as a sham authority case, but the judge specifically in this case avoided using the word, and he referred to the arrangement as artificial, but not a sham. So something can be artificial, but not a sham. Now, these cases were also all property law cases, and usually with a landlord-tenant cases, there's a huge inequality in negotiating power. And so in my view, these are really poor examples to argue that sham trust exists. It is almost suggested in this case and the cases it relied on that actually it was the doctrine of mistake that was operating, that the parties had merely registered their true intentions incorrectly. So these are not really sham cases, actually. Now we move again onto another key case. You might have heard of this one, Midler Bank versus Wyatt. Again, held up as an authority for the Sham Trust. So in this case, you had a defendant husband, and he'd been advised by professional legal advisors to enter into a trust arrangement. The arrangement was that he and his wife declared that they held the property on trust as co-trustees for the wife and the two daughters. It appears that the trust was created merely for asset protection reasons in case the husband set up a business. However, in finding for the claimant, the court held that the trust transaction was void because of Section 423 of the Insolvency Act. So the sham argument here was distinctly secondary and ultimately redundant, because it would seem it was merely thrown in as an alternative argument in case the Insolvency Act argument failed. And a more recent example of this is Alliance Bank versus Zunis. So look, what happens is lawyers will always throw in the sham trust argument. It's like a last bone in case everything else fails, or if you're trying to help the judge out, you'll throw it in. But as we're seeing, the judges will look at it, but they'll never really decide a case on it. Good examples here. So what these cases demonstrate is that we have a variety of individuals using trusts, often due to advice from professional advisors, for matters in addition to aiding family succession, such as avoiding tax and blocking the actions of creditors or a spouse in a matrimonial dispute. They are then challenged in this time period before the courts, almost due to their moral status. And if you remember when we looked at Lord Diplock and Snook, he referred to morality as a factor relevant to shams. However, the courts clearly remain reluctant to base their decision on sham arguments, preferring alternative rationales to reach their decisions. So it still doesn't exist, does it? I'm now, we're going to now look at international clients, but still, we really haven't found any evidence of a sham trust existing. But now we're going to look to the key case. Now, this is the case that drove me crazy. Rahman. Now, you've got a picture there. Rahman, that's where I started my career. That building was the HSBC Private Bank and Trust Company in Jersey at Grenville Street. And 2 doors down was JP Morgan Chase. And that was where Chase Bank Trust Company was that was involved in this Rahman case. So perhaps everybody in the building that I was in were rightly very scared of Rahman. But I decided to have a look at it. So this case really shattered the confidence of the offshore industry. It was really the first major offshore sham case. Now, as we have noted, the sham concept is entwined with not only the development of tax and asset protection planning, but also with that of the so-called offshore world that I previously introduced. And we've noted that the offshore trust was starting to be used more liberally and was already coming into conflict a bit with the mainland courts. The English courts had a much broader desire to protect other case holders rather than the settlors, like the offshore trust world was. And as we will see, this really came into effect with international divorces. So of immense importance to international clients. So you've got international people now coming and using the offshore world, buying land. Obviously, a lot of these people were drawn to the UK because of the non-dom rule. They were advised to set up and use the offshore world before they came. Now, this Abdul Rahman case was kind of a bit of a backlash against that, which we'll talk about in a moment. But also, I think it's quite interesting because a lot of these international clients had no idea what the matrimonial English courts were about and how they were very much looking after spouses in divorce hearings. So of immense importance to most individuals who are not from a common law country and therefore are not familiar with trusts being part of a family succession planning culture, who are not operating in their native language and who are dealing with all these foreign advisors, where usually they're very skeptical of having to deal with all these professional advisors, is that they want to retain control. And this is where we have seen the development of offshore reserve powers trusts in offshore jurisdictions, for example. So these issues raise 2 concerns. Firstly, that is the settler just being sold a legal device? Is just yet another financial tool? And second, that the assets which are subject of the trusts, are they going to become objects of judicial attention in other legal forms, such as the family courts, which is exactly what happened. So quite simply, however, it would appear that there was little consideration given from individuals or entities acting as trustees how to reconcile this. Perhaps no one cared. Whilst the lucrative trustee fees were rolling in, it was not until these foreign settlers ended up in English matrimonial disputes in the family division of the English High Court, for example, who were more interested in protecting a wife's often unsung contribution to marriage, that attention as to the correctness of the so far freewheeling allowed in the offshore world, where the settler lots of settler control was attacked. So really, this Abdul Rahman case was really the first time that the offshore judiciary started to rein in settlers. Like I said, it was these international settlers now, not UK people. And it was starting to be seen that they were being abused. So Rahman involved a settler who had substantial control over the trust assets. Mr. Rahman was able to instruct the trustees' bankers to transfer funds and implement investment decisions without the trustee even being aware of this. The trustees were merely seen as being there for a rainy day and to implement the wishes of the settlor. The commercial pressures facing the fee-charging corporate trustee, which was a branch of one of the largest US banks, so as you can see, we're a far cry away now from the gentleman trustee of the Victorian era, was evidenced from internal communications discovered during the proceedings, as was the trustee's lack of any sort of independent reasoning or control over the trust assets. So the trust in Rahman was declared void ab initio. However, yet again, this is not a sham case. Yes, even Rahman itself, the definitive offshore sham case, has actually nothing to do with a sham doctrine. How the case actually turned was on Norman customary law. So in Jersey still does follow Norman customary law to some extent, and it was a maxim noted as donner et retenir niveau, and this appears to be a proper equitable maxim under Norman law, and that means that to give and to hold back control over the substance of a gift at the same time is not accepted as a valid legal transfer. Making a gift means to relinquish control of property and to transfer it to another person or without retaining rights or powers. So the maxim is a public policy device in Jersey to protect heirs and creditors against imperfect or fraudulent purported gifts. So really, Rahman is an imperfect gift case under Norman law. It, yet again, is not a sham case. But as I've said, really perhaps here what was happening here was the offshore judiciary decided they needed to rein in the offshore excess a bit, and they were perhaps with the mainland courts in mind. And this did open the floodgates a little bit, and I will concede on the following case that this is probably the closest there's ever been to a case being decided on a Sham Trust finding. Again, it's another Jersey case, and this case involved the enforcement in Jersey of an English divorce judgment. So it's Fountain, which followed an English case called Minwala versus Minwala. Again, the Jersey court did put sort of sham label on this. However, I do find this poor authority. This is because the Jersey Royal Court no doubt needed to balance a requirement to not be too obstructive to the English courts, but at the same time, it would not have wanted to open the floodgates by authorising the automatic enforcement of an English divorce judgment, which would have had a very detrimental effect on the island's trust industry. So the sham label perfectly allowed them to do this. The trustee of the Jersey Trust, though it was not supervised by the English court, had admitted to the English court's court jurisdiction, and the trust had been found to be a sham by the English court. Again, though, there seems to be a decision that could just as readily have been decided on a lack of certainty of intention on the part of the settlor. He never really intended to give away his assets to a trustee. Instead, Mr. Minwala was a well-advised man who had already been divorced more than once before and was simply seeking to limit the repercussions of another divorce. But let's have a look what was going on in England then, because that case suggests that, well, actually, in England, they were starting to find things as shams. And, but you know, what we sort of say in law is bad cases make bad law. And I think Fountain is a good example of that. The Jersey Royal Court was placed in a difficult place. So I would still say it's not really a definitive sham doctrine that's emerged. Now, there were actually two English law cases at the time which back up that point that I've made. So we have Hitch versus Stone, which provided a further analysis of the sham trust concept in English law. So Hitch involved some really aggressive tax planning over UK land, which were even using like Singapore companies. But in this case, the judge noted that just because something is artificial does not mean it is a sham. And what he said was that they were not shams because, though artificial, the parties intended to give full effect to the terms. So that's really interesting, isn't it? You create some very elaborate structure, but if everybody intended to run it, that's not a sham. It might be artificial in that it's very constructed, but it's not a sham. And then again, in A versus A, this is a very important case because it did involve a very learned judge. So this is, again, classic English divorce judgment with an international settlor. And once again, in this case, the learned judge derided the sham concept. He said, a case, the sham allegation that is, which, as I have said, should probably never have been brought, was allowed to continue limping on to inevitable defeat. So this was a very senior judge known as Mumby J. And he was very careful not to say the sham doctrine existed, nor that it didn't exist. And he sort of did his job, my job for me, actually, because in that case, he outlined other legal devices that could have been at play. So the Ecuador maxim that equity looks at substance rather than form. That means, they look beyond the four walls of the agreement, as we've seen. The Ramsey principle in tax cases. Around this time, you had a key case, Press versus Petrodel. So courts were starting to pierce the corporate veil at this time. It could have been a resulting trust. He does mention the sham doctrine. And then, of course, he mentions powers under the Matrimonial Causes Act. So I would also now add to this that, and you're going to see this when we look at other jurisdictions, where it's a tax case, they're not going to claim sham trust anymore. They'll still throw it in. They'll throw the argument in. But they'll go straight for general anti-avoidance rule now. So I think there's actually going to be even less development of the sham trust concept, if there is even such a thing, because now Parliament basically has put these general anti-avoidance rules, and they exist in most common law countries. So we note the key difference between something being artificial and being a sham. But what we also should note is this concept of morality. And I've sort of summarized this here. I'll read it to you. And this is important. So the sham doctrine, as was noted by Mumby J in A versus A, is applied with the same methodology in relation to contracts and trusts. It is at its most basic, simply a way of finding that an agreement, including a trust, is not to be followed because it does not reflect the true agreement between the parties. The crux of the matter is, and what makes the sham doctrine so unclear, such that it is tempting to jettison the idea and explain it via other terms, is what factors make up this intention. What needs clarifying is the elements of this process that are unacceptable. If the agreement and intention to enter into it and to follow its terms is pure, but that the moral justification for the agreement is unacceptable, for example, the sole reasoning that gave birth to the intention was to give a negative effect to other members of society, be it a spouse in a divorce hearing, fellow taxpayers, government treasuries, or a creditor bank, then at some point this may, it seems, lead to a transaction being potentially a sham because this immoral reasoning was noted as the main rationale for the transaction. And I would also add that, there's me trying to argue a sham doctrine for you, but is it really up to the courts to put morality rules and regulations in place? I would say not. That is the job of the legislature, and I think really that's kind of what they've done with general anti-avoidance rules. That it's being made clear that tax avoidance is unacceptable, right? So now, no review of shams would be complete without a review of what the academics are saying on this. And really, the best paper on shams, I would say, comes out of New Zealand, and I would recommend to you Professor Matthew Connauglin's paper. Later on, I actually do list out the names of the papers, and you can look them up. I think Professor Matthew Connauglin's is the best academic opinion on the concept. You can also read Jessica Palmer's work. Again, she's New Zealand. A lot of stuff came out in New Zealand because there were arguments happening in the courts there, but also because in 2010, the New Zealand Law Commission did a big review of their trust law. So Connoglan, why he's important is because he thinks there is a doctrine. He does think that there needs to be common intention by both parties, and he says subjective intention, so not objective. What do they actually say was their intent, not what you think their intent was, although we'll come on to that in a moment because the courts disagreed on that. And that there needs to be an element of dishonesty. And he does believe that you should look beyond the four walls of an agreement. But he's very much arguing for this looking at the intention. And really, what he's saying, the sham concept, is that it sort of allows and authorizes a court to ignore the usual ways that they would view and construct a transaction. It allows them to look at other factors which indicate what the intentions of the arrangement were. So there you have it. It might very well be that, but that's the clearest argument for a sham trust, I would say. But that's not really what we see in the courts. Okay, so we're coming to our final part. So really, at the end of 2007, it probably suffices to say that there is simply a loose device to allow a court to depart from the facts presented to them, where none of the other legal doctrines, for whatever reason, allow them to, or perhaps where the court does not want to give its underlying full reasoning or analysis as to why a decision was given. It appears that there is a need for common intention and also an element of deceit, whereby the documents presented are not the true agreement. Certainly, some element of morality seems to play a part in what is still a very vague notion at this point. Now, I put the final epoch as sort of taxation and technology. I feel that all the tax changes and laws that came in from 2008 and really from 2012 could be put down as a sort of tech disruption, right? Because technology allowed tax authorities to exchange cross-border all this information. So it's a bit of a tech disruption. Obviously, international bodies such as the OECD have got way more power as well. So you have the sort of the more of international bodies rather than individual states, implementing laws. So really, we could say it was the end of the tax planning era. And we'll look now at some of the other jurisdictions of the common law world to see if we can find the sham trust concept there, because I think at the moment I'm still happy to conclude that it doesn't exist, the sham trust concept. So a key case was in America, Credit Suisse case, where they really kind of developed the sham doctrine in American law. But what you'll find under most of these laws, particularly American and Canadian law, is it's all tax cases. And as you know, the courts there have got absolutely they're not mucking about. They are going to bust open a trust if there's anything to do with tax. Looking at the US courts, that they've taken a much sort of tougher stance than the English court, which I think the English courts is still very narrow approach to it. Karen Moore's paper is worth reading, which I referenced there. She sort of criticized the sham transaction as basically permitting courts to avoid doing any analysis. So her view is that it obscures and discourages analysis. So it's kind of a way of a court avoiding a proper analysis and just implementing the tax decision that the IRS really wants. So perhaps there is something in America, but really only around tax. Now, New Zealand is kind of like the hotbed of activity. There's the two papers I referred to, Palmer and Connoglan's paper. So really, as I said, the key point coming out of New Zealand is this kind of intention that needs to be bilateral. So the trustees' intention is really relevant, and this is going to be really interesting when we look at Pugachev in the epilogue. So Connolly's view is correct. This has been said by Professor David Hayton, and also the Jersey case of Group Taurus and the English case of Shelson and Russo again confirmed that the settlor and the trustee have to both be colluding in order for a sham to be found. Other jurisdictions, again, Canada, very much tax kind of driven sham concept. Australia follows much more the English approach, although they have, again, in tax cases, suggested it might exist. Singapore's rejected it. So Singapore had a case which was really similar to Midland Bank versus Wire, and despite the questionable intention to credit trust, they thought there was nevertheless intention and rejected the sham argument. And South Africa and in India, again, it's tax cases where we see it. So very much tied with tax in other jurisdictions. So let's conclude, and then we'll look at the epilogue, and then if there's any questions, we can answer those. So in conclusion, and this is a conclusion around 2016, in conclusion, there does not appear to be a coherent sham doctrine in English law. The authority suggests that there has been an unwillingness to establish a doctrine. The English courts do not want to open a can of worms, but more to the point, they've never been asked to. No substantive legal trust issue has ever been solved by a sham doctrine. Indeed, most of the commentary in sham cases is obiter, as I explained before. Alternative explanations of note are the view of Connoglan in New Zealand and more in the United States, where they view the concept as one which allows certain evidence to be ignored or considered in a very flexible manner to allow a court to serve justice in a case where the court is clearly trying to avoid being tricked by the parties. Common intention of both for all parties seems necessary, as does an element of ill morals. It is unlikely that a case will ever be found on us now, especially in tax cases which will just use the GAR rules. But a litigation lawyer will always chuck in the argument as a last resort, as a get out of jail free card if everything else fails. In my view, judges will never use the sham argument because it would open the floodgates. But at the same time, they'll never dispose of it from the legal toolkit. It is the place of the legislature to do this. And as we've seen in the GAR rules in tax law, perhaps they have done that. Now, we finish with our epilogue. So Pugachev is held up now as the ultimate sham case. So Pugachev was a Russian oligarch, and he owned a bank, and that went bankrupt, and basically there's a Russian bank coming after him for billions of dollars. And I finally reviewed it, and I couldn't believe what I found. The judge in the actual case says there's no such thing as a sham trust. So yet again, my point proved. The ultimate case being held up as a sham case, the judge himself said there's no such thing. Now, what is interesting in this case is that basically what he said was, well, yeah, but look, it's not a discretionary trust, it's a bare trust. So the documents were potential shams. And he ruled that there was a bare trust, not a discretionary trust, and that the assets were therefore held for Pugachev. What's really interesting in this case, though, is that the question of the common intention came up, and the trust had been set up by quite a prestigious lawyer in New Zealand. This lawyer had also done a presentation before about sham trusts. I think it was called "When is a Trust Not a Trust," which actually got referenced in the judgment. So I hope my presentation today is not going to end up in a judgment, but we'll see. And the judge even specifically says in the case that he had to sit down and think hard about the common intention, because what the gentleman setting the trust up said, well, he said, I fully intended to follow the terms of the trust. And he said, he actually said, which was held against him, he said, I don't really know the settler's intention. I know that he wanted this trust, and my intention was to implement it. And I think the judge kind of, I question this ruling. He sort of said, well, do you know what? I don't believe you. I actually think, looking at everything else, you're just an agent of the settlor and you're doing what he says. So I don't believe what you're saying. And I'm just going to rule that, therefore, your intention is exactly the same as the settlor's because you're just an agent of him, which I thought was quite extreme. But as we say, look, bad cases make bad law. This is a very highly political case, as you can imagine. I suspect the New Zealand government were under pressure here, and judiciary were under pressure to make sure the right decision was given. And so not a sham trust case at all. And you should really read this case. Go online and read it, because there's lots of evidence of what kind of came up in the case and what made the trustee look stupid. Basically, emails, poorly written emails, especially with the family office as well. Run by some Russian and Swiss people, I think it was. So yeah.